What do Olympic medals and prison sentences have in common? According to the Supreme Court, more than you'd think. The court, in Hewitt v. United States, untangled a knot of statutory language, retroactivity, and criminal justice reform with some surprising conclusions. This Supreme Court case tackled one of the trickiest questions in sentencing law. What happens when a long sentence is thrown out after Congress changes the law to reduce penalties? This all starts with the First Step Act of 2018, a sweeping criminal justice reform that aimed to reduce overly harsh sentences, especially under 18 U.S.C. Section 924C, which tacks on heavy prison time for carrying a gun during a violent or drug crime. Before the act, stacking these charges meant that even first-time offenders could face decades behind bars. Congress addressed that issue. The act eliminated mandatory stacking for first-time offenders, but made it retroactive only in cases where a sentence has not been imposed as of the act's enactment. That seems simple, right? Not quite. Enter Hewitt, Duffy, and Ross, convicted of bank robbery and Section 924C offenses in 2009. They were originally hit with extremely long sentences. Years later, some convictions were overturned and resentencing followed. Then came United States v. Davis. This landmark Supreme Court decision invalidated part of the Section 924C statute that led to more sentences being vacated in 2022. So here's the legal puzzle. When these men went back for another resentencing, years after the First Step Act, could they benefit from the new, lighter sentencing rules? The Fifth Circuit said no, because they were originally sentenced before the act was passed. The retroactivity clause didn't apply, even if those sentences had been thrown out. The Supreme Court disagreed. The majority court zeroed in on the phrase "has not been imposed." That verb tense, present perfect, was the key. The court reasoned that a vacated sentence is legally void, as if it never happened. So if a sentence has been vacated, there's no sentence in place, meaning one has not been imposed. And that wasn't just grammar parsing. The court also relied on the legal principle of vacatur. When a court order is vacated, it's treated as void from the beginning. That meant these defendants were legally standing at square one, and entitled to resentencing under the First Step Act's new, more lenient rules. Not everyone agreed. The dissent took a more literal approach, arguing that if a sentence existed at all, at any point before the act, it counted. In their view, Congress didn't say anything about vacated sentences, and the majority was overreaching to serve a policy goal. They also warned against letting legislative intent override the plain statutory text, even in the name of justice reform. But the majority pushed back, noting that the act's purpose was to end the harsh stacking regime once and for all, and that their reading better aligned with that goal. They even used a clever analogy. If an Olympic champion is stripped of their medal, we don't say they still have it. The same logic applies to vacated sentences. So, what's the practical takeaway? If someone's Section 924C sentence was vacated after the First Step Act, they can now be resentenced under the new, lighter rules, even if their original sentence was imposed before the law changed. That's a big win for defendants facing excessive prison time and a step toward a more consistent, fair sentencing system. Beyond the immediate impact, Hewitt v. United States is also a case study in how the Supreme Court balances statutory text with real-world consequences, and how a single verb tense can change lives. This case may not have grabbed headlines, but its ripple effects will be felt across courtrooms for years to come.